good afternoon, and good evening. Welcome to Course 1B of the Monique and Roland Weil People's Academy of International Law. I am Marjorie Cohn, founding Dean of the People's Academy and a member of the Bureau of the International Association of Democratic Lawyers. In Course 1A, Phyllis Bennis, Jean Myrer, and I served as faculty. We presented the history of the UN Charter, the contradictions within the Charter, the prohibition on the use of force as applied to Gaza, the right to peace, and the responsibility to protect. Today, we will focus on using the Charter to litigate and organize in support of people's struggles. Our faculty will examine the illegality of Israel's assault on Gaza and litigation alleging the illegality of the Iraq War. We will also hear a critique of the UN Charter. We have French, Spanish, and English translation. Please put your questions in the Q&A box for our discussion following the program. In the next few days, we will post the faculty presentations in English, French, and Spanish on our website, peoplesacademy.net. Our faculty for today's course includes Richard Falk, Dave-Inder Comar, Sujith, Xavier, and Roberto Zamora. Each faculty member will speak for 30 to 35 minutes. Then the faculty will interact with each other. That will be followed by Q&A with the registrants. Our first faculty member is Richard Falk, who is also a member of the Scientific Committee of the People's Academy of International Law. He is Albert G. Milbank Professor Emeritus of International Law at Princeton University and Chair of Global Law, Faculty of Law, Queen Mary University, London. Since 2002, he has been a research fellow at the Orphelia Center of Global and International Studies at the University of California, Santa Barbara. Between 2008 and 2014, he served as UN Special Rapporteur on Israeli violations of human rights in occupied Palestine. Richard has advocated and written widely about nations that are captive within existing states, including Palestine, Western Sahara, Catalonia, and Donbass. He has been nominated for the Nobel Peace Prize several times since 2008. In 2001, Foreign Affairs selected his This Endangered Planet as one of the 6 most influential books on global issues published in the last 100 years. Richard's most recent book, with John Dugard and Michael Link, is Protecting Human Rights in Occupied Palestine, Working Through the United Nations, which was published this year. Richard, thank you for joining us.
Thank you, Marjorie, for having me, and I'm very glad to be part of this innovative educational effort that the People's Academy of International Law is attempting to make. And I would just comment that international law is really dependent in the area of war and peace on people. Governments have disappointed and failed, particularly the leading governments. And so it is only through the agency of people that international law in the peace and security area will receive the kind of support that is necessary to obtain the results that are embedded in the expectations and hopes of the UN Charter. And we see that in the context of the ongoing genocidal onslaught on Gaza, that it is the protests of people rather than the initiatives of governments or the autonomous action of the UN that has most seriously attempted to achieve a ceasefire and end the horrible unfolding of violence in that beleaguered and surrounded Gaza area. Let me begin by making a couple of preliminary points that I think explain at least how I view the UN and the Charter as frameworks for the pursuit of peace and security. It should be, and maybe has been already in prior sessions, noted that the UN came out of the experience of World War II, and especially the concern that the world could not handle a third world war likely fought with atomic and then nuclear weaponry. In other words, war prevention was the uppermost objective of those that gathered in San Francisco to finally establish the UN as an operative organization. I think the second kind of preliminary point that seems to me to be crucial is that the secondary concern was to avoid what had happened to the League of Nations after World War I. That is, that the countries that needed to be most regulated either didn't join, as in the case of the United States, or withdrew, as Germany did, or were expelled. In other words, the League of Nations was seen as failing in part, not because it gave rise to another war, but because it couldn't serve to create a framework that would govern all countries in the world, at least all countries that were significant in relation to peace and security. Now, the third point that I would try to make is the notion that because of these first two concerns, ironically, the UN was designed to be weak. One can put it in a more strong, provocative way. It was designed to be a failure when it came to the management of power in relation to peace and security. Now, I say that because there would be no other reason to give the 5 winners in World War II the power of veto and control of many of the functions performed by the UN, such as the selection of the Secretary General and the compliance with decisions by the International Court of Justice or the advisory opinions issued by the tribunal. This was left in the hands of 5 countries that, whenever their own strategic interests were engaged, or that of an ally, they could exercise a right of veto, which means that they could paralyze the only organization within the UN system that had the power of decision. Now, one may ask, why was something as perverse as this introduced into the structure of the UN and accounting for disappointment with its performance? And the answer is partly to overcome the problems of non-participation that had afflicted the League of Nations. So here was a way of giving assurance to these powerful countries that their interests would not be encroached upon by participation in the UN. But it was a high cost to pay, because it meant that the most dangerous and powerful countries were potentially out of reach when it came to peace and security, war prevention, and the central undertaking of the UN. And this partly reflected the somewhat naive views of the American president, Franklin Delano Roosevelt, who thought the veto wasn't going to be a big issue, because since these countries had cooperated in war, there was the war against fascism and Japanese imperialism. There was no reason to think they couldn't cooperate in peacetime. And that neglected the history of international relations, which shows that big powers, so-called great powers, give priority to strategic ambitions rather than to cooperating in a common effort to preserve peace, security, and promote justice. So there is that contradiction built into the very framework of the UN, and has greatly encroached upon its practice over this long period. So in terms of my preliminary points, the UN has been a great success from the perspective of participation. All the important countries have participated. None of them have exercised their right to withdraw or been subject to expulsion, though that's sometimes mentioned in the heat of political conflict. The universality of the UN has been an achievement that at least enables diplomatic interaction in periods of crisis. And that has proved to be a valuable resource of responsible statecraft. But it is far from enough, and it is far from a full understanding of the significance and limitations of the UN over the course of its history. I would like to emphasize the fact that even in relation to peace and security and the management of power, where what has emerged over the decades since 1945 is a clear picture of an organization in which what I call geopolitical primacy has prevailed. That is, the most powerful countries can either enable the UN to be extremely effective, as it was in the first Gulf War or in the intervention in Libya, maybe too effective if the consensus that emerges seeks objectives that are not entirely in keeping with the spirit of the UN Charter. And in both of those instances, one can make that argument that the UN lost control over these events and either was misled or didn't have the capacity to supervise the authority that it conferred on these powerful countries to engage in uses of force authorized by the Security Council to rectify situations of aggression in the Iraq War of 1991, where the objective was to coerce Iraq to withdraw from Kuwait that it had conquered and annexed, and it proved successful in terms of attaining that objective, but it also inflicted a lot of gratuitous suffering on the people of Iraq. And in Libya, there was a very limited authorization of the use of force, but it wasn't adequately supervised. And although the Security Council had authorized force to protect the civilian population of Benghazi, and gave NATO the authority to implement that decision through a no-fly zone and related measures, in actuality, the NATO engaged in a regime-changing intervention that executed the legitimate leader, Gaddafi, in a very brutal manner. And it showed how, when the UN is manipulated by these geopolitical forces, the Charter can be cast aside rather dramatically, and the UN doesn't have enough what I would call institutional gravitas to address such behavior that exceeds the authority that it has given. In other words, its weakness is exhibited in these several ways. And finally, the weakness is that it can speak about wrongdoing, as in Gaza currently, but it can't enforce either the norms of the Charter or the recommendations and decisions of its principal organs. That is, it has the UN is afflicted by what I would call two levels of crisis. One is a implementation crisis or an enforcement crisis, that its norms that are enacted by UN procedures can be resisted without consequence. And Israel over the years has proved a master of this kind of defiance of the supposedly binding international law that was given a special status in relation to occupied Palestine after the 1967 war, in which Israel was expected by Security Council decision to withdraw to the pre-67 borders, but in the interim was to act as an occupying power subject to the restrictions of international law as embodied in the Fourth Geneva Convention, particularly governing belligerent occupation, and that imposed an overriding duty on the part of the occupying power not to act in any way that jeopardizes the safety and security of the civilian occupied population. It can maintain reasonable administrative security, but it must attend, as spelled out in Article 55 of the Geneva Convention, it must, under all circumstances, ensure that the population has food and medical supplies adequate to its needs. And so we see this implementation crisis that the UN can set standards and it can even reach decisions about those standards. The Human Rights Council has appointed special rapporteurs and established commissions that have come with very persuasive reports, and these have not altered the behavior of Israel. In fact, they have been flaunted, and that defiance has been given a kind of quasi-legitimate status because it's been over the years more or less supported by 3 of the 5 permanent members of the Security Council, most of all by the United States. So what we have as a result is we have an organization that can express its views that often go against the ideas and policies of the P5, but it can't implement them. And yet, despite this frustration, it's important not to underestimate the role of the UN, because what it can do is establish a certain symbolic legitimacy for civil society to act in a responsive way. So in other words, even if important states ignore the authority of the UN, civil society can be mobilized in various ways, either spontaneously or by organized movements, to take seriously the judgments of the UN on issues of legitimacy and illegitimacy. And these symbolic issues often are crucial in determining the outcome of political and military conflicts. It's notable that all of the anti-colonial wars were won by the side that had the inferior military capabilities, but had on their side the legitimacy of their struggle, which was validated by UN norms about liberation, resistance being a part of international law, and strengthened nationalist movements. So what I'm trying to say is that in this area of peace and security, the UN is substantively disappointing and weak, but symbolically important and influential, and that shouldn't be forgotten. Another related point is that the UN is much more and has evolved in a much more hopeful way in relation to other aspects of human well-being, ranging from climate change to treaty making to protection of cultural heritage and to economic development, so that it should not be judged by its own charter in a way. The charter does give this impression that the organization is only about war prevention and saving succeeding generations from the scourge of war. It is certainly centered on that concern, but it has evolved over this period of now more than 75 years into a very valuable framework that provides daily reinforcement to a set of values that are vital for the well-being of people, particularly in vulnerable and least developed or less developed countries. This was evident during the COVID crisis, when the WHO suddenly became a household word and was looked to define the status of the disease as a pandemic, and it provided a framework that could lend assistance where it was needed. It was underfunded and undercut by the US again. Trump defunded the WHO in the midst of the pandemic. So that it's important to examine both the achievements of the UN and the constraints that arise from this double effect of the primacy of geopolitics and the state-centric character of world order that still leads even those states without the veto to pursue their national interests rather than the interests of the world as a whole, either the global interest or the human interest, is not in concrete circumstances how governments participate within the organization. The overriding ethos is one of doing what's best from a perspective of the sovereign state that is acting within the framework of the organization. And so when one thinks about the future and whether these features can be overcome, one, I think, is guardedly optimistic that the pressure of unsoluble challenges like climate change will induce a level of cooperation for the sake of the survival of the species that may at least soften this geopolitical primacy and this secondary influence of national interests and so-called political realism. So when looking toward the future, I think it's crucially important to try to strengthen international law through reforms of the UN that indirectly weaken this geopolitical control. For instance, there's no reason to keep the authority of the International Court of Justice at the advisory level when organs of the UN seek guidance from the judicial body. That notion of an advisory opinion again makes the idea of international law a voluntary one. You don't have to comply. It's a matter of this is what international law prescribes, and if it doesn't conflict too dramatically with your with the national interests of a particular country, this is what it should responsibly do. But that's not enough in the world that is so ecologically and politically at this point challenged by issues it cannot and will not control. See, again, in the final point about Gaza, if the United States and the EU acted responsibly, they would join in the condemnation of this excessive use of force against civilians that has been now generated a civil society consensus that it is a genocide, in fact, the most transparent genocide in all of history, where the horror of the impact on civilian society is brought before our eyes through the imagery of the digital age. So all the world is experiencing the horror that has befallen the Gazan people, and yet the most powerful country that prides itself on the rule of law and constitutionalism and democracy endorses this distortion of legal argument to suggest that Israel is only defending itself. And what we know from international law is an occupying power has no right of self-defense. And in addition, this act, the attack of Hamas, was a traumatic event, but it doesn't give rise to a genocidal response. So that there's much of value in the UN, but there's much to be concerned about in its inability to regulate the worst features of international society. Let me stop there.
Thank you so much, Richard, for detailing the geopolitical limitations of but abiding significance of the UN Charter. We tend to say, throw the baby out with the bathwater, and there are various views on this, but it is important to keep these nuances firmly in mind because they are quite significant. So thank you for that. Our next faculty presentation will be by Dave-Inder Comar. Dave-Inder is executive director of Just Atonement Incorporated and the managing partner of Comar Mole LLP. Dave-Inder's public law practice deals with climate change, human rights, international governance, and international law. Through his nonprofit Just Atonement Incorporated, he also trains aspiring human rights defenders to combat threats to human rights and a habitable planet. Between 2014 and 2017, Dave-Inder litigated a first-of-its-kind lawsuit against President George W. Bush and other members of the Bush administration, alleging that the Iraq War was illegal. The lawsuit utilized the UN Charter and the Alien Tort Statute and sought to hold the president and other members of his administration responsible under international law for breaching the peremptory norm of international law, which is called jus cogens, prohibiting aggression. And that norm is codified in the UN Charter. Dave-Inder is licensed to practice law in California, New York, and before the US Supreme Court. He is currently a PhD candidate at the Grotius Center for International Legal Studies at Leiden University, where he is researching the impacts of climate change on international law, self-determination of peoples, and how the international system must evolve to address planetary threats and resolve conflicts. Inder Comar, thanks for joining us today.
Thank you very much, Marjorie, and it's a real pleasure to be here. I'm very grateful for the opportunity to present some of what I've done in the past and some of my research with respect to international law. So I'm going to share my screen here. Great, so this is the last slide. So let's go to the first slide, and I'm just going to make this full screen. So I'm going to be talking about today the UN Charter, aggression, and the war in Iraq, and how those all things interact, and some thoughts on where we stand today in terms of the Charter's ability to govern relationships between states and to try and work for a peaceful world. So as you all probably discussed last time, the Charter incorporates mechanisms to try and diffuse conflict, to try and de-escalate conflict, and also to ensure compliance with the prohibition against aggression, which is a peremptory norm of international law. It's a basic component of international law. It's basically, it's like a fundamental building block by which the international system is supposed to operate. So when these peremptory norms get violated, it's a structural problem. It's a crack in the foundation. And the more cracks that you have in the foundation, over time, the edifice that you have tends to collapse. And so in the Charter, there are a few provisions that go directly to this peremptory norm prohibiting aggression. And one is Article 39, which is in Chapter 7 of the Charter. You might know of things like what's called the Chapter 7 powers, and that's the power of the Security Council to make a determination as to handle threats to the peace or breaches of the peace. And under the Charter, the UN Security Council has powers, and it can enforce its measures and its decisions through the Charter on all of their members. So it has treaty authority to bind other members to the decisions from the council. And the purpose of that is to provide some kind of proto-sovereign, I would say, quasi-sovereign, stem cell sovereign, maybe, something very, very basic in terms of how states are supposed to comport themselves. And as you probably discussed last time, the Security Council is composed of 5 permanent members, which are the victors of World War II, as Professor Falk just mentioned. And in addition, there's rotating members who serve for a number of years, and they rotate on or off, and there's elections to the Security Council. So in addition, the charter also contains a general prohibition against aggression in Article 2.4. Members must refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state in a manner inconsistent with the purposes of the charter. And then finally, you have Article 51 of the charter, which is the right of self-defense. And this codifies a fundamental right of states and of peoples. But in this case, it's talking about states, the member states, to defend themselves in the event that they suffer an act of aggression on their own. So these 3 provisions are some of the provisions that help us think about how conflict situations can and should be de-escalated. And these are legal obligations on members. In theory, these are binding legal obligations to comply with these provisions. So I'm going to turn now with that as background, to the Iraq War and this lawsuit, this domestic lawsuit that Marjorie referenced in the introduction, and talk about how some of these norms were attempted to be applied in a U.S. domestic setting, and what we can learn from that experience. So first, just as background, there was a first Gulf War, or a first Iraq War, what's sometimes called the Gulf War in the United States, between 1990 and 1991. And in this situation, you had the UN Security Council passing a resolution, UN Security Council Resolution 678, what's called the All Necessary Means Resolution. So this resolution, there is some critical scholarship of it based on its language, but basically it empowered all necessary means to enforce compliance with its resolutions. In the US, there was a debate that ultimately led to a joint resolution being passed by Congress that was signed by George H.W. Bush just a few days before the air war began. And so what you see here is, I guess you could see, this is an instance you could say of the council and international law and again, this proto-sovereign of international governance, quote unquote, acting as intended. And I put that in quotes because, as Professor Falk noted, the brutal consequences on civilians that took place even when the system was, quote unquote, working as intended. And part of that was this sanctions regime that was also imposed by the UN Security Council that devastated the people of Iraq for years and years and years, up until the next war. But in this instance, I think it's important because it's important to describe the system as how it worked, because it provides a even more, I think, interesting and devastating comparison with what happened in 2003. But I think for purposes of here, it's just important to note the Security Council passed a resolution. The United States Congress passed a resolution, which is an interesting resolution. I encourage you to read it because it references many of these UN Security Council resolutions as the foundation for U.S. military action. And it was signed into law, and then a couple of days later, the air war began. Now, in 2003, the situation, so this was after the first Iraq War, the Gulf War, you have a resolution passed by the UN Security Council in November 8th, 2002, Resolution 1441, which gave the government of Iraq a final opportunity. This was the word it was used. It's a long resolution, and you can tell when you read it in hindsight how the compromises and the backroom deals that the member states were obviously engaged in to preserve their positions as to what should take place, because there's a lot of, I wouldn't say contradictory, but paradoxical language in this resolution as to what it means. And and what its impacts are if it wasn't followed, because 1441 makes references to Iraq being in material breach already of its international legal obligations and providing Iraq a final opportunity for compliance. At the same time, there's language in there, noting this is an ongoing process, and there's certainly not anything language about all necessary means that you saw in the previous resolution from 1990. And so prior to the war, there was a debate within governments, and we know this because of the Chilcot report that was put out several years ago from the UK, where there was a basically full disclosure as to the legal discussions taking place in the United Kingdom to the legality of the war, and there was a big discussion internally, at least in the UK, and I'm sure in the US I don't think we have those materials actually yet, as to whether or not this resolution revived, it's called the revival theory. If it revived the resolution from 1990, thereby giving member states authorization to just go ahead and attack Iraq for noncompliance, and related resolutions like Resolution 687. And so proponents of this theory argue that the language, again, of 1441, which was so broad, that it basically revived the previous authorization given in 1990, 13 years earlier, subject to the Security Council making a determination that effectively negotiations were over and that there were breaches, but based on that, there was not a need for a formal Security Council authorization. Now, in those discussions, we also know that the U.S. took an even more aggressive position, which is that it could determine on its own whether or not these resolutions were in fact being breached by the government of Iraq, which is a more radical position than even the UK's position, which was that the Security Council had to make a finding. So in tandem, just as like I showed you in 1990 or 1991, there was a debate in Congress, and so that culminated in the authorization for use of force, passed October 16, 2002 by pretty wide margins, at least in the Senate. And it was a very it was not as there was a reference to all relevant United Nations Security Council resolutions, but it wasn't as detailed in terms of the international law as the 1991 resolution. And it gave the president the authority to use the armed forces of the United States as he determines to be necessary and appropriate to defend the national security of the United States. And so this is the heart of that resolution. Now, a standalone UN Security Council resolution with respect to the 2003 conflict was never obtained. So when the U.S. attacked Iraq on March 19th, 2003, there was not yet a second resolution, which is what kind of the nomenclature at the time, or just even a first resolution, I mean, arguably, in terms of the invasion of Iraq. So then you're left with, this revival theory, if you want to comply with international law, which I'll get to in just a second. So yeah, I actually skip slides here, but in the absence of a UN Security Council of this second resolution, or of this 2003 resolution, was the war lawful? So then, you go to the charter and you say, well, was there Chapter 7 authorization? And so, that's what international lawyers like Lord Goldsmith, not Goldstone, Lord Goldsmith was saying at the time, is that that the resolution came from 1990, that you had these older resolutions that basically gave the authorization. And we can debate that or talk about that later. I think a lot of scholars and a lot of people looking at this at the situation think that's a very weak argument, but it's an argument, and it's one that was presented in 2003. So let's assume you don't even have that, or that's a weak argument. Then you go to self-defense, which is the Article 51 basis. And I don't think anyone really made a claim of self-defense behind closed doors. Now, there was certainly rhetoric about self-defense in that there was arguments presented to the United States public that the government of Iraq was in league with al-Qaeda. None of that was true, or that the government of Iraq possessed weapons of mass destruction. Again, none of that was true. So, but those arguments were rhetorical arguments trying to make a self-defense claim, not an international legal basis. Self-defense under international law requires an imminent use of force, And so none of those things I mentioned would describe an imminent use of force. So you don't have self-defense. And so then finally you have this third grounds for an attack against another country, which is this very controversial grounds called right to protect, which you don't hear about much anymore, but it was talked about a lot more in previous years. This idea that governments can humanitarianly or can intervene on a humanitarian basis to help civilians. And that was a purported third ground here. And again, I think rhetorically, you did see a lot of that being stated back in 2003. But I think behind closed doors or in the international legal briefs, there was very, very little discussion of this because it wasn't really a concern. I mean, this, again, keeping in mind that Iraq at this time was still subject to a grueling sanctions regime. So, I mean, if humanitarian concern was an issue, I mean, why not start with the sanctions? But anyway, this is the discussion of how you kind of look at how, you know, this attack may or may not have been lawful. So then talking about the planners of the war, and here I'm moving more towards my work and less, I think, about what maybe other international lawyers might talk about. But I think this is very relevant because when we're talking about enforcing international law, right? So who were the planners of this war? And based on my work back when I litigated this case that I'll get to in a second, many of the high-ranking members of the U.S. administration had expressed militant views about U.S. foreign policy prior to entering office. They were very clear that it was a very clear ideological belief that international law was an impediment on U.S. power. There was a belief in the need for American international political dominance, and there was a belief in the need that military power was the foundation for that dominance. So it's not just that America had to be dominant, but that it was going to be dominant through its military. And there was a clear written record for many of these people who served in the administration, high-ranking members of the administration, that this was their ideological belief and what they were going to implement upon coming to power. So going to whether or not the attack was lawful, I think, you know, I sum up mostly by the former Secretary General comments that the war was illegal was his determination that he made in September 2004 because of the fact that just in the simple analysis, or not simple, but straightforward analysis, you know, was it self-defense? Was there Security Council authorization? And then, you know, you can talk about whether there was a right to protect or some humanitarian basis, again, noting that that's a controversial basis. But Secretary General Annan's conclusion was that it was not lawful. So moving now to the lawsuit. So in 2003, I was the lead lawyer on a case that we filed a class action in the Northern District of California seeking damages for the war as a tort action. In international law, you'd call these reparations, but in the U.S. Domestic context, this was a civil suit for damages from the planners and the wagers of the war, including former President Bush and several other high-ranking members of his administration. And we were also seeking a court order declaring the war illegal. So we actually wanted a court to adjudicate the lawfulness of the war. We had jurisdiction under a law that's on the books today, the Alien Tort Statute, which is a very old law in the U.S. that gives non-U.S. citizens the right to enforce international law in certain circumstances. Now, we could do a whole hour on that law, but unfortunately, there's not a lot of time. But I would say that that this law has been, or the jurisdiction of this statute has been very limited in recent years, starting in 2013 or thereabouts with the Kiobel decision. And so, but before 2013 or thereabouts, or 2016, whenever Kiobel came down, it was in that time period. This was one of the key global pieces of legislation that lawyers were using to enforce human rights norms. It was almost a crown jewel of sorts in terms of international legal circles in enforcing international law. And all that's basically gone away. The Supreme Court has limited it to matters that touch and concern the United States only. It's limited the reach of foreign jurisdiction. It's done a lot to limit its scope, and it's not as powerful as it once was. But we took the position that this was definitely a matter of the United States, and that all the decisions took place in the United States. And the claim that we sought to enforce was aggression under customary international law, and as defined in the Charter. The citation primarily to the Nuremberg judgment and customary law grounds, as well as treaty grounds, the treaty grounds being defiance of the Charter. So what happened is, as we started to litigate, the issue of aggression almost became a side issue. So the issue that became forefront was whether or not these defendants were immune. And there was a question of immunity that was raised under domestic law, and in particular, this Westfall Act of 1998, which is currently in the news with respect to former President Trump and whether or not he can be sued for a variety of conduct taking place during his administration. And so this statute is relevant as ever, and it was relevant back in 2013, 2014. And in our case, the Westfall Act permits the Department of Justice to immunize a government employee from a civil claim. And so the Department of Justice at that time, even though it was a different administration, sought to immunize these former officials. And this was the issue that ended up being litigated up and down the courts in terms of appeal, was whether or not there was effectively immunity. And so the question was whether or not these defendants were acting within the scope of their employment. And this is a kind of the law, if they're acting outside the scope of their employment, then they can be sued. And so we argued that breach of the Charter and breach of customary international law was always outside the scope of the employment. And we cited to the Pinochet case from the UK High Court back in the late 1990s, in which the law lords at the time took the position that defiance of international treaties was effectively you're always acting outside the scope of your employment if you're a government official, because the treaty is the policy. We've ratified this treaty. If you act in defiance of this treaty, well, then you're not comporting yourself with office policy, so to speak, and you're acting outside the scope of your employment. We also argued that the defendants were predetermined to engage in war, citing to their pre-administration statements about, and in particular, about attacking Iraq. And we tried to make the argument that under domestic law as well, there's an exception here when an employee goes on what's called a frolic and detour. So if the employee steals the company car, goes to the beach, and hurts somebody on the way there and back, or on the way back, that's a frolic and detour. You can't sue the company because the company's policies prohibit all that. And this employee did something totally on his own. And so we tried to argue this was a frolic and detour. And both those arguments were rejected on the grounds that what the court said and what the Ninth Circuit ultimately said was that planning a war is central to what government officials do, irrespective of what laws might be broken. And so accordingly, they were immunized, and the court rejected international law on those points. So that was basically what happened in this case. And so, just to sum up on some reflections and thoughts, is international law actionable in the US? Well, I don't know. I actually don't know the answer to that. And I think you have some very old case law from the 1900s and with beautiful language, flowery language about how international law is enforceable in federal courts. But I'm not really sure. And I think, I think it depends. There's quite a lot of litigation in which the courts have basically decided they just don't care about international law. So, this is a very important question that we have to ask: is international law actionable, or is it simply just a principle that can be ignored, or is it even a principle that even gets talked about? I think a second reflection is, what is the legacy of Nuremberg? Nuremberg was an attempt by the victors of the war to enforce some legal accountability, to encourage the flowering of international law post-World War II. Again, very strong language about the need to prohibit aggression. Aggression was the chief crime that was prosecuted at Nuremberg. And what is its legacy when when we can look back now and see a long list of aggression that has taken place since Nuremberg without any possibility, it seems, of some kind of justice because of those acts. And does the prohibition against aggression carry any weight today? I think this is a very important question we have to ask in light of the fact that several powers, not just the United States, but a lot of it has been the United States, but several powers are committing aggression, and there doesn't seem to be a way to stop it. And so, what do we do when we see these cracks in the foundation? Like I said at the very beginning of this presentation, that you have this fundamental norm that doesn't get respected, and there doesn't seem to be a court that can enforce it. What do we do? I mean, this is an open question. What is the continued weight of the Charter? The prohibition against aggression is a chief pillar of the Charter. And what can we say about the weight of the Charter today? I think this is an important question we have to ask. What is the role of immunity? This is not an issue that I had really thought. I thought the issue of aggression was going to be the one that was going to get litigated, but instead we ended up litigating immunity, just as they did in Pinochet. Now, in the Pinochet case, the outcome was the other way. But I think when we talk about leadership crimes or violations of law undertaken by leaders, we have to confront this aspect of immunity, because I think immunity becomes an under-talked about shield that prohibits or prevents real accountability and real compliance with the international rule of law. Is it possible to envision a world in which crimes committed by global North leaders are subject to legal review? And what would be the role of the Charter in that kind of world? So we have to undertake a process of imagination now. We have to really imagine that world where that kind of accountability exists. And what does that world look like? Who is filing complaints? Where are those complaints filed? What kind of judge hears those complaints? How does a warrant get issued? Have we even thought? Have we imagined that enough? I mean, really, I think there's a real crisis of imagination. And I think we have to start imagining that kind of world and working for that kind of world. And then finally, how do we conceive of sovereignty in a world that's facing planetary threats? And I think this is a critical issue because, from my perspective, with aggression, also with climate change, the pieces of wisdom that give me the most insight are come from legal theory, come from Hobbes, come from Locke. Understanding that we possibly live in a state of nature or a state of war without a sovereign or without any kind of law that binds us together in some kind of global community. So what does sovereignty look like in a world where human rights are protected, where the planet is protected? I think that type of world and that kind of sovereignty might look very different than what we think about today. And again, there's an imagination exercise that we have to undertake here to imagine the kind of sovereignty that we need to keep us safe in a world that seems to not be able, that doesn't seem to have the capability at present to prevent conflict, to de-escalate conflict, or to protect our precious planet from being destroyed. So with that, I thank you for listening, and yes, looking forward to what the other participants have to say.
Thank you so much, Inder Comar, for explaining why the 2003 war on Iraq was illegal, the limitations of the use of international law in the United States, and also posing what are really significant questions that we need to grapple with. So thank you so much. Our next faculty member is Sujith Xavier. Sujith is Associate Dean for Research and Graduate Studies and Associate Professor at the Faculty Law of the University of Windsor. His research spans domestic and international legal theory, including third world approaches to international law, or TWAIL, transitional justice, and Canadian public law and racialization. Sujith is a founding member of the editorial collective of the Third World Approaches to International Law Review. He is active in the legal profession as a member of the Law Society of Ontario, and he has significant experience working with grassroots organizations in Sri Lanka. Sujith has appeared before the Supreme Court of Canada and the Canadian Federal Court and Federal Court of Appeal. He teaches legal theory to Master of Law (LLM) students and public international law, administrative law, and race and the law to JD students. Sujith is co-editor of Decolonizing Law, Indigenous, Third World, and Settler Perspectives. He is currently co-editing a special issue on race and racialization in Canada for the Journal of Law and Social Policy. Thanks for being with us today, Sujith.
Thank you, Professor Cohen, for that wonderful introduction and for your patience with me. I think, can everyone hear me? I think you all can hear me. So let me just begin by first acknowledging the fact that I was slated to speak during the first class in November, but alas, I was sick with COVID. So thank you, Marjorie, for being patient. And I also want to thank the other organizers and the participants. It's wonderful to see such interest in international law. And it is also an honor to be part of this cohort of instructors. I'm truly humbled to be in the presence of Professor Falk, whose work I have admired and cited often. Professor Falk, it's good to see you again. I think we caught up in Los Angeles a few months ago, or last year, I think. So let me begin with what is traditional in these parts of where I'm at. And let me start by noting that I'm speaking to you from the traditional territories of Indigenous peoples. I'm speaking to you from the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, and the Haudenosaunee, and the Wendat peoples. And it is now home to many diverse First Nations, Inuit, and Métis people. This place that I am now on is known as Toronto, Ontario, Canada. When I started doing this work, I was living on the traditional territories of the Three Fires Confederacy of the Ojibwe, the Odawa, and the Potawatomi, which is where I work as a tenured law professor and a refugee settler. In Canada, it is now customary for us to recognize the sovereignty of Indigenous peoples and their sovereign claims to the territories that many of us are on. Traditional international law, however, has often forgotten the significance of international law or international laws between Indigenous peoples, and I hope that we can work to make better connections. In this vein, traditional international law has forgotten its significance to the peoples of the Third World as well. In fact, some of us, as part of Third World approaches to international law tradition, have sought to bring the Third World, especially the experiences of racialized people, back into the conversation about international law. So in the next 30 minutes or so, I want to offer to you a third worldist view of the United Nations Charter. In doing this work with you, I'm relying heavily on the work of my comrades and colleagues in the Third World Approaches to International Law movement, including Dr. Usha Natarajan, Dr. Lara Betancourt-Restrup, and others. In what follows, I will first set out quickly what I mean by Third World Approaches to International Law, or a third worldist view, and then turn to two claims that I want to make from this perspective about the UN Charter. The first claim is that the UN Charter was never meant for third world peoples. And the second builds on the first to show how the UN Charter and the organs that implement the Charter are not committed to equality for all. Rather, they're only committed to the equality of some, or for some. The second point that I want to raise with you is based on how the United Nations Security Council has deployed its charter powers to make referrals to the International Criminal Court. So let me just move to the next slide, which is the beginning of the first part of my remarks. So let's turn to this discussion around what do I mean by a third worldist view, or TWAIL. So let me ask the question, or let me start with the question of what is TWAIL. For some of you in the room, the moniker third world may seem offensive. Yet, I think it is a cursory view of the term, or I think being offended by it, you may be taking a cursory view of the term. And we forget that it was first coined by a French scholar, Alfred Sauvy, to describe the place of some countries in the current economic system. Since then, scholars like Vijay Prashad have complicated our understanding of this term to mean that it denotes a political project to describe how certain countries were conceptualized to be in a third place as opposed to the first world. The political project was about peace, bread, and justice. And here I'm borrowing directly from Vijay Prasad's work. So in this context, a network of scholars and activists have come together to really think about the role of international law in this political project. There is some controversy about when the TWAIL network started. Some of the scholars in the network suggest that it started with lawyers like former International Court of Justice Judge Mohammed Bejawi, or scholars like R.P. Anand. I myself have argued that TWAIL's origins can be traced back to the important dissent of Justice Powell in the Tokyo Tribunal. And, here, let me kind of tie this back to what was mentioned earlier in the context of Nuremberg. And we often forget the ugly sibling of Nuremberg, which is Tokyo. And in it, Justice Powell made one of the most profound dissents. And in that context, Justice Powell, or in Justice Powell's dissent, his dissent, one can argue, has a basic orientation of anti-colonialism and anti-imperialism, and it's embedded within the 1,200 or so pages of the text. I think it is one of the longest dissents ever written thus far in the context of international criminal justice. So whatever the origins of TWAIL may be, it is clear that this network has evolved. It is often described as a big tent with many folks from different political perspectives. When I say political perspectives, I mean there are those that want to reform the international law system, like what Professor Falk had laid out earlier, and then there are those that want to upend it. Notwithstanding these differences, we can clearly identify several tenets of TWAIL. TWAIL can be characterized as an anti-hierarchical, counter-hegemonic coalitionary movement that is deeply suspicious of universal creeds and truths. It is anti-hierarchical because it challenges the Eurocentricity of the history of international law and continued propagation of a particular monolithic set of universal values. Third World Approaches to International Law, or TWAIL, calls for the recognition of existing inequities within the structure of international law. It also calls for the recognition of subaltern voices and demands that all voices be represented. Broadly, the movement's unifying raison d'etre, according to Professor James Gothi, is to challenge the hegemony of the dominant narratives of international law, in large part by teasing out encounters of difference along many axes, such as race, class, gender, sexuality, ethnicity, economics, trade, etc., and in interdisciplinary ways, such as social, theoretical, epistemological, ontological, and so on. By challenging these dominant narratives, Professor B.S. Chimney suggests that TWAIL seeks to reduce the distance between distance of the world of international law from the lives of ordinary peoples. And ultimately, I would argue that TWAIL, Third World Approaches to International Law, is about the lived experiences of racialized peoples in the global South. So, in thinking about TWAIL's central tenets, Professor Makua Mutua formulated three overarching central tenets for TWAIL in 2000. And since then, the movement has grown. I was recently in Bogota, Colombia, where close to 52 scholars from the Global South had gathered to think critically about TWAIL. So in light of all of this, let me try to give you the Coles notes of what is TWAIL. One of the central aims of TWAIL is to understand, deconstruct, and unpack the racial hierarchies embedded within international law. Importantly, and here this is the second element, the second component is to think about prescription. TWAIL scholars seek to create alternative normative legal edifices for international governance. And the third tenet is through policy scholarship, TWAIL scholars aim to eradicate the conditions of underdevelopment in the global south. But even this framing that I have just presented to you is contested, and I must confess that for me, as someone who's worked in this field, I oscillate between reform and abolition. I'm pausing here because I can hear an echo, and I think someone needs to mute their mic.
Can someone please mute their microphone? We're hearing some background noise. And Sujith, the interpreters ask you to speak just a little bit more slowly for their interpretation.
Thank you, Marjorie. I
Thanks.
forgot about it. Thank you. So as I was saying, given the three kind of tenets of TWAIL that I've just presented, one of the things that I struggle with as someone who's been working in the third world approaches to international law space for the last 15 years is to come back to the arguments that Professor Falk presented, which is, how do we reform the system, or do we take the lines of what has been presented to us in the context of the racial consciousness that we have all become aware of in the United States and in the global north and in the global south recently, especially in terms of the lived experiences of enslaved peoples and how it's really hard for us to escape those realities. And so in that sense, I'm finding myself oscillating between reform and abolition. And now that I've presented to you what is TWAIL, let me shift to my kind of two arguments that I want to present to you about the UN Charter. And here you will probably see how the ways in which I oscillate between reform and abolition kind of come into play. And I'm happy to pick this up during the Q&A. So in light of what I've presented as some of the foundations of TWAIL, perhaps now we can move into my first claim about the UN Charter. This is a historical argument that I want to present to you, turning back to how the Charter was drafted and by whom. What I'm trying to illustrate are two elements here. The first is that the words on the page have different trajectories in how they were forged and how they were interpreted. And two, the historical context of how these words were forged matters in how we understand them today. I normally teach public international law from the perspective of third world approaches to international law. And in week 3 and 4, the students in my class and I often read Mark Mazauer's No Enchanted Palace. Mazauer had spent years in the archives gathering documents about significant figures involved in the drafting of the UN Charter and how the UN Charter was created. In this text, in No Enchanted Palace, Mazauer has a wonderful chapter on Jan Smuts, whose image I've reproduced in my slides, and his role in drafting the UN Charter. Smuts, as some of you may know, was the architect of the South African apartheid system, which was modeled on the reservation system that the Canadian state had set up to deal with indigenous peoples of these lands that I'm speaking to you from. Smuts, a well-known white supremacist, was very active in the creation of the League of Nations. He had a close relationship with President Woodrow Wilson at that time. In fact, when Wilson arrived in France after the First World War, Smuts had helped him formulate a vision of the League of Nations. Of course, Smuts' vision was based on the idea that the former glory of the British Empire must be maintained. Parts of these ideas, of course, helped guide how the League of Nations conceptualized the colonial possessions of Germany and the Ottoman Empire. The language of tutelage that found its way into Article 22 of the Covenant of the League of Nations was something that Smuts had favored, and this found its way into that provision. And this becomes relevant for us today because, if we go back to what Professor Falk had laid out earlier, that, Article 22 of the Covenant of the League of Nations helps us understand why we are in the current predicament we are in, and why we are witnessing the carnage we are witnessing in Gaza and in the occupied Palestinian territories. So as we watch the carnage unfold in Gaza today, we can be grateful to the legacy of Jan Smuts for setting up the legal structure that facilitated the creation of the State of Israel. And when I say we can be grateful, of course, I'm being sarcastic here, right? And in this context, some of you are probably wondering, what does this have to do with the UN Charter? Well, I think it has everything to do with the UN Charter. As you know, the United Nations inherited through the United Nations Charter, inherited the mandate system that was forged during the time of the League of Nations. And the mandate system was institutionalized in Chapter 12 of the UN Charter. Of course, on the books, the Trusteeship Council and the mandate system is now part of our international history. But this is not really true, though. While some of the states that were part of the mandate system may have achieved decolonization, their freedom has yet to fully be realized. And the best example of this is the situation in the occupied Palestinian territories, which brings us back to the UN Charter. Jan Smuts had a crucial role in the formulation of the Charter's preamble. And here I have reproduced the preamble in the slides. There was a lot of debate at the Dumbarton Oaks Conference about the type of power that should be ascribed to the UN Security Council. Whoops, sorry, I didn't mean to move the slides. So as I was saying, there was a lot of debate at Dumbarton Oaks conference about the type of power that should be ascribed to the United Nations Security Council. More importantly, the discussions at the conference, according to Mark Mazur, folks were at the conference were leery of repeating the mistakes of the League of Nations. And at times, there seemed to be a lack of cohesion in what the UN was meant to achieve. And according to Mazur, this is where Smuts, the well-known white supremacist, stepped in. Before the meeting in San Francisco in 1945, Jan Smuts attended the meeting of the Commonwealth Ministers in London. And here he presented the idea of a preamble to the United Nations Charter as a means to win popular support. And I've included the text in the slides, as I noted earlier. Once Smuts had the approval of the Commonwealth Ministers, he took his text to San Francisco, where it was adopted unanimously with a few modifications. And so the text that we have, that's part of the preamble, was written by Jan Smuts. So while speaking at a closing plenary session, Smuts says, as an old veteran of the wars and of peace conferences, he hailed the Charter as a good, practical, workmanlike plan for peace. And here I'm quoting Mark Mazur's text from page 61. What does Smuts' role in drafting of the preamble of the UN Charter tell us then? Here, let me make several reflections. The first is that the history of how the UN Charter was created and by whom is important. Of course, as lawyers, we know that words have particular meaning at particular moments. Words also evolve. I usually go on and on about the rules of treaty interpretation to the students in my public international law class and how words can evolve and take on new meanings. But this does not change the fact that it was a well-known white supremacist that drafted the preamble of the UN Charter. In fact, TWAIL scholars have spent years trying to illustrate how racial superiority is baked into the language of the UN Charter and the UN institutions. In this context, I think it does matter who drafted the preamble and for what purpose. Speaking of the Charter as an emancipatory document that will generate freedom for all, then may not be that accurate. And here, let me, before I move on to the next section, let me leave you with a final reflection. And that is that this point that I want to make is that the preamble is something that we constantly refer to as we the people of the United Nations, or the preamble in the charter, we are constantly citing to it, we, the people of the United Nations, to affirm the faith and fundamental human rights, etc. But if we were to go back to Smuts and think about the context and the ways in which he imagined the human, his idea of the human that's embedded in this text is not the same as ours. In fact, many of us in this room will not be considered human, worthy of rights in the same way for Smuts. Right? And this is a history that I don't think we can afford to lose sight of in this particular moment, as we watch the carnage unfold in Gaza, where human beings are being killed because they are savages, or quote unquote, right? There's tons of language that we can go to in that context. So that's the first kind of claim that I want to make about the charter. Now, I may be running out of time, so I'm mindful of this, but let me try to frame my second third worldist view of the charter through the Security Council's relationship with the International Criminal Court. And this builds on from the first point that I just made, in that it picks up on some of the powers of the Security Council and its relationship with the International Criminal Court. Let me give you some background first. The International Criminal Court was created through the Rome Statute that was drafted by nation states, international non-governmental organizations, and non-governmental organizations as part of a conference that took place in Rome in 1998. The statute of the court was open for ratification for 4 years, and the court started its important work in 2002. The central task of the International Criminal Court, or the ICC, is to prosecute international crimes. There are 4 international crimes: the crime of genocide, the crime of war crimes, the third is crimes against humanity, and the fourth is aggression. And this is all set out in the statute. So far, many TWAIL scholars, including myself, have argued that there is a racial hierarchy in how cases are selected for prosecution by the International Criminal Court. Rachel Lopez, in a recent chapter, notes that there is an overwhelming prosecution of Black people by the International Criminal Court, and this has engendered a type of white guilt. So here are some of the stats that I was able to pick up for you for this talk. The court has concluded 12 proceedings, and of the 12 proceedings, 11 are African situations, and 1 is a North African situation. Currently, there are 5 trials that are unfolding. They're all African situations. There are several pretrial proceedings. I've given you the names of the proceedings. There are 8 pretrial African situations, and there are 2 North African situations before the court. And there are currently 17 investigations, and of the 17, 7 of these are focused on non-African situations, which includes Palestine, the Philippines, Ukraine. But these situations haven't reached the level of, or hasn't reached the court yet. Yes, there are preliminary decisions by the pretrial chamber, but it hasn't reached an adjudicatory phase just yet. They're just investigations. And of course, there are 3 preliminary examinations in Nigeria, DRC, and Venezuela. So they're all Latin American and Africa. So the question then is, how do these cases end up before the ICC? Article 13 of the statute sets out 3 ways. The first, or the first 2 ways, are not really that relevant. One is through state referrals, or self-referrals as is known, or through the initiative of the prosecutor. And these are known as trigger mechanisms, right? And this is all set out in that statute. But the third, or what I would say the most important provision within this is 13B, which gives the power of referrals to the United Nations Security Council. And this power was built into the statute as a way to embed the UN Charter, Chapter 7 powers of the United Nations Security Council. That is to maintain peace and security. I don't have time to go into the drafting history of Article 13, but what was envisioned in this in granting this power to the Security Council was to ensure that we don't end up with another genocide, for example. Right? Because remember, the drafting of the statute took place in 1998. This was on the heels of the two genocides in the former Yugoslavia and Rwanda. And so we, that was one of the precipitating factors in creating the court. So, and here, let me kind of, I guess, gesture to the fact that this was the purpose of the court, was to ensure that genocide is prohibited. So in this context, of course, the next question is, how has the United Nations Security Council exercised this power? And this is a power that's vested within the UN Charter. And here, the United Nations Security Council has made referrals in two instances, but these referrals are some of the most contentious. And the two examples that I want to focus on are on Libya and Sudan. So in the context of Sudan, the International Commission for the Inquiry on Darfur was established by the former United Nations Secretary General, Kofi Annan, pursuant to the Security Council Resolution 1564. The Commission reported to the UN in January 2005 that there was reason to believe that crimes against humanity and war crimes had been committed in Darfur, and recommended that the situation be referred to the ICC. So, using its power under the Rome Statute, the United Nations Security Council referred the situation in Darfur since July 1st, 2002, to the prosecutor of the International Criminal Court through Resolution 1593 in March 2005. And the numbers that I gave you earlier in terms of the cases before the ICC include some Sudanese cases. And of course, there's a deep history in terms of why the African Union, or lots of members of the African Union, wanted to leave the International Criminal Court because of the court's attempts to prosecute the former president of Sudan, right? Which comes back to questions of immunity, et cetera, that was alluded to in the previous by the previous speaker. Now, the second example is that of Libya. And on the 26th February of 2011, the United Nations Security Council decided unanimously, 15 votes in favor, to refer the situation in Libya since February 15, 2011, to the International Criminal Court prosecutor, stressing the need to hold accountable those responsible for attacks, including by forces under the control of those responsible on civilians. And here it was all about attempts to protect civilian, and the language of the responsibility to protect was invoked, etc. After conducting a preliminary examination of the situation, the ICC prosecutor concluded on March 3rd, 2011, that there is a reasonable basis to proceed or a reasonable basis to believe that crimes under the ICC jurisdiction have in fact been committed, and they opened an investigation. And of course, there are cases now being decided, or that there are completed cases from Libya. Right, and here let me pause and pose the question: why are some cases being referred to by the United Nations Security Council to the ICC and not others? And when I started my kind of presentation or my remarks, I alluded to the fact that I'm a refugee who's living now on stolen lands. And so I come from, my peoples are from the northern part of what is now known as Sri Lanka. And in 2009, the Sri Lankan Buddhist nationalist state decided to eradicate the Tamils for a whole host of reasons, including a racial reason. And in that context, they pushed close to 150 to 300,000 people into a strip of land that is the size of Manhattan on the shores of Murli Baikal, and they commenced the genocide. And as the genocide was unfolding, UN officials had left, etc. There were no media there, and no one was bearing witness except those of us who were outside. And many of us were trying to advocate to get this before the Security Council. And the Security Council was not interested at all in referring the case to to the ICC prosecutor or the International Criminal Court. And in the similar way, what is happening now in Gaza, which is also another strip of land, the same size as, Molly-Baikal, is under a similar kind of attack. And there's been numerous attempts to get this to the, or get a referral, or there's been attempts to get the Security Council to act. And of course, we all know why that is. But, and, we can say, sure, when you compare Libya and Sudan, the context is very different. There are politics at play, etc. And we can quickly brush this off as the politics of the day. Of course, we understand that the United Nations Security Council members have a vested interest in Palestine and in Sri Lanka, and thus the referrals are not possible. Sure, we can make this argument, but this does not tell us, but this does tell us something about the inherent nature of international criminal prosecutions and the use of Chapter 7 powers by the Security Council, and how it engenders a double standard. So in the context of this double standard, there is a significant body of TWAIL scholarship that picks up on the idea of double standards in international law. For example, in 2003, professors Tony Angie and Bhupinder Chimney signaled to the double standards and the victor's justice evident in how international criminal institutions operate in a paper in the Chinese Yearbook of International Law. Here, I've given you the citation in the slide. So Angie and Chimney in that 2003 piece argue that there must be a consistent and objective approach to initiatives directed towards establishing individual criminal responsibility. They suggest that the lack of consistency, especially in the selectivity of cases, lead to the systemic reproduction of double standards and the confirmation that international criminal justice is selective, premised on North-South power dynamics. And I would argue that it is premised on a racial hierarchy. More recently, other TWAIL scholars have pushed similar broad critiques of international criminal justice and its respective institutions, such as the United Nations Security Council. Some TWAIL scholars have explored the selectivity of prosecutions in international criminal law and the operational selectivity in the ICC cases. And some of us are worried about the focus on the African war criminal to the exclusion of the Israeli or the Sri Lankan singular war criminal. And some of the remarks that I've just made now in the context of the double standards was part of a piece that I wrote with John Reynolds in 2016. And let me conclude by saying that there's a rich body of literature that kind of takes on a third worldist view that has been kind of coming together over the years. And I think it's important for us as international lawyers to pay attention to this, which comes back to the point that Professor Falk made about social movements, right? Because the growing demand of the global South that says, look, this system is not working for us. This system of knowledge production, the system of laws that exist are not working for us, must be taken seriously if we are to move forward. And in this context, I think for me, while I'm sympathetic to the arguments around reform, I also think that there is some deep, deep value in saying that the system is not working and it needs to be upended. And we really, really have to change it, whether it's by burning it down or ignoring it. Thank you.
Thank you so much, Sujith, for setting forth the contradictions between reform and abolition of the UN Charter, and also detailing the racial hierarchy in Security Council referrals to the ICC, and indeed the cases that the ICC actually does take up. So thank you for that. Our final faculty member is Roberto Zamora. Roberto is a human rights lawyer in Costa Rica. In 2003, as a third-year law student, Roberto filed a legal challenge to Costa Rica's support of the US-UK-led aggression against Iraq. The Constitutional Chamber of the Supreme Court ruled that the support given by the Costa Rican government was unconstitutional because it violated the value of peace, the Costa Rican Neutrality Declaration, and the UN Charter. The court ordered the withdrawal of Costa Rica from the so-called Coalition of the Willing. Major victory. Roberto also filed a legal challenge to the Costa Rican's president to allow the manufacture of nuclear fuel and nuclear reactors for all purposes in Costa Rica. The Supreme Court annulled the president's decision as violative of the right to peace and the right to a healthy environment. With this ruling, the Costa Rican High Court recognized the right to peace as a human right of international dimension. Roberto also convinced the court to forbid the use of legally forbidden military weapons against civilians by the police. In 2018, Roberto won the case that overturned the ban on same-sex marriage in Costa Rica. Roberto, we're delighted to have you as part of our faculty today. Thank you.
Hello, Marjorie. I don't know if you can see me. Other members of the faculty and attendees to today's session. It is a pleasure to greet you from sunny and warm Costa Rica. And after listening to the brilliant presentations we have had and having that sense of despair that comes from the reality that we see in the field in our lives, maybe I can bring a little bit of light of hope in terms of the role that the international system can play. Marjorie, am I on screen?
Yes, you are on screen. Yes.
Okay. It's just I don't see myself, but it doesn't matter. Okay,
Yes,
so
we see you.
Okay, thank you. So as Marjorie said in the introduction, I have had the chance to successfully use international law, particularly the UN Charter, for the prevention of escalation of conflicts, for the prevention of participation in armed conflict of a country, and in general, for the upheaval of international peace. I will put on the slides. I have share screen. Okay, do you see the slides?
Yes, we see the slides. We see them.
Okay, thank you, Marjorie. So one thing that I want to reflect on, and Richard briefly referred to it, is that international law has a weaknesses, that it depends on the will of states. And as we'll see in a bit, consent remains a fundamental piece and part of international law, although it's not the only source of obligations of states. So we will use the cases, particularly the case I raised against the Costa Rican government for supporting the coalition of the willing, to see this interaction and how this worked in my case. There is some contextual issues that I will also touch upon, But let's just start at the moment with some basic concepts that will be important for you to take into account. One is which are the main instruments in international law, which are the UN Charter and its annex, which is the Statute of the International Court of Justice. Keep in mind that the Statute of an International Court of Justice is not an independent document, but it's an annex to the UN Charter. And then we have the 1969 Vienna Convention on the Law of the Treaties, which is pretty much the constitution of international law as it regulates how international obligations are to be understood. How do you agree to an international obligation? Then we have what are the sources of international obligations, which are basically consent. And consent create sources of international law, which are the treaties that states sign, and then unilateral acts, which are decisions that a state makes unilaterally with the intention to create an obligation towards third states. Neutrality being one of the most easy examples of a unilateral declaration. It's a state that by its own decision decides to be neutral, and that creates an obligation towards the rest of the states, because now a neutral state cannot either take party or become a belligerent. So, as I mentioned, consent, as well as it is the main source of international obligations, is not the only one. As Dave said, we have peremptory norms, which are established in Article 53 of the Vienna Convention of the Law of the Treaties. These are rules, as he says, that are considered so fundamental to the system of international law that without them, the system cannot function. And as such, they apply even without the consent of states. And then we have rules created by custom. Now, it's not just the custom of states in terms of their practice, but also how they perform this practice. So states must perform their acts assuming that they are doing or performing such practice because there is an obligation behind. So this is what is known as opinio juris, which is the will of the state to assume that practice, considering that is because there is an obligation to do the practice in such way. And finally, we have, besides the obligation to submit to a treaty, there is the obligation to comply and fulfill the obligations derived from those sources of international obligations, which is the clause of pacta sunt servanda on Article 26 of the Vienna Convention of the Law of the Treaties, which basically means that what you have packed must be served. You must fulfill your promises, as simple as that. And you also have to do it in good faith, which is a principle of international law which has binding character, as it is also included in the Vienna Convention on the Law of the Treaties. It has also been highlighted in several resolutions of the ICJ, including the nuclear test case and the case concerning the Temple of Preah Vihear. Now, before going specifically into the case that I raised, it is very important to understand something, which is that Costa Rica is a very, very strange country. when it comes to international law and to its state practice, particularly when it comes to peace. You might be, maybe you know Costa Rica for only two reasons, which is peace and environment, which are peace and environment. So Costa Rica was the third country in the world to abolish the death penalty after San Marino and Venezuela. This happened in 1877. When founding the Second Republic in 1948, we abolished the army. We just happened to celebrate the abolishment of the Army Day last December the 1st. Costa Rica also declared itself a neutral country by unilateral declaration in 1983. And here is something very interesting, which is that Costa Rica has a full legal monist system, which is that there is no distinction between domestic law and international law. As soon as an international obligation is acquired by the country, it self-implements into part of domestic legislation. So in Costa Rica, you can directly claim violations to international instruments of which Costa Rica is a state party, or by other international obligations derived from custom or peremptoriness of certain norms. In Costa Rica, the Supreme Court can check the constitutionality of laws, decrees, and other administrative acts regarding their compliance to human rights law and regarding their compliance with international law in general. Also, Costa Rica is one of the few countries with the widest acceptance compulsory jurisdiction for the ICJ. Costa Rica did not submit any kind of reservation when accepting the compulsory jurisdiction of the ICJ. So as you can see, there are two things that we can take from these historical facts, which are one, that Costa Rica does have acted, there is state practice in terms of acting towards the protection of peace in whatever form you want to understand it, a right, a value, or a principle, but also that Costa Rica trusted in the new order that was being created with the UN Charter based on the rule of international law. A sort of leap of faith. Okay, now we can start, after all this background, to tackle a little bit the situation of the Iraqi invasion. So the first thing that we have to take into account is Resolution 1441, as Dave very accurately pointed. This resolution, as he also pointed, decided to allow Iraq a last chance to fulfill its obligations that had been set by previous Security Council resolutions regarding the inspections of their weaponry capacity building facilities, particularly those related to forbidden or restricted weapons. Now, by no means it can be interpreted that Resolution 1441 authorized the use of force. And this is very, very important because we will use this later. And not only it happens that it explicitly doesn't authorize the use of force, that it also decides to give a chance which would be very contradictory to give you a chance while I attack you or use force on you, at least invade for the particular case. But before the UN, it can be understood that there is any authorization of the use of force, according to Article 39 of the UN Charter, it is mandatory that there has to exist a determination of a breach of the peace or a threat to the peace or an act of aggression. It is not sufficient to have a breach of previous resolutions. There has to be a determination of a breach of the peace or a threat of the peace, and neither of those existed in Resolution 1441, which means that whatever use of force that happened after these resolutions, well, after this resolution was not in accordance with Resolution 1441. Now, for the resolution, so we can firmly and without any doubt affirm that the invasion of Iraq was beyond the UN Charter, in violation of the UN Charter. At least we can say that it was not authorized. Now, for the understanding of the resolution of the case from the Supreme Court, there are some legal instruments that we that are applicable, and then I will just mention. So domestically, there is the Costa Rican Constitution, which in Article 7 provides that Costa Rica is bound by whatever international obligation it acquires. And it also, within the sources of domestic law, puts international treaties just under the Constitution and above the regular law passed by the Congress. In Costa Rica, human rights instruments have force superior to the Constitution, which is very, very interesting. They have supra-constitutional value. I told you Costa Rica is a very, very strange country. As it goes to international law, I know I'm making a distinction here, but it's just for academic purposes. As I mentioned before, that Costa Rica is a full monist system. So to me, it doesn't make any relevance making this distinction. So I'm just making it for academic purposes. Internationally, we have Chapter 7 of the UN Charter, particularly the provisions that I had in the previous slide, Articles 39, 40, and 41. We have the Vienna Convention on the Law of the Treaties, Article 26, that you might recall referred to the Pacta Sunt Servanda principle, and the Statute of the International Court of Justice, which establishes in Article 38 the sources of international law. In our particular case, we are interested in source establishing Article 38.1.b. Sorry, I'm sorry, there is a little mistake there, which is custom. Should be B instead of C. I'm sorry about that. And then we have an element of dual character, which is the neutrality declaration, because it is a unilateral act of international law, but it is also an administrative act of domestic law. So it does have that dual character beyond the monist system. The case, since this was the first case ever to happen, there was no previous case law applicable to this case, which was, for my purposes, it's fantastic, because that allowed me some creativity and I thought it would be a good idea to demonstrate to the court a customary rule of domestic law, but applying the mechanisms of customary rules of international law, as if Costa Rica had created a unilateral and individual obligation through custom. And I tried to prove the court that Costa Rica had created a obligation through custom to the right to peace in both its positive and its negative sides. Positive is Costa Rica not involving with war actively, and positively in terms that Costa Rica should engage actively in the resolution and de-escalation of active conflicts, utilizing its neutrality. So, as I mentioned before, I went through Costa Rican history, and well, I couldn't get the Supreme Court to buy my argument in this case. I did manage to get the Supreme Court to recognize the customary existence of an international right to peace created unilaterally by Costa Rica as a customary rule of domestic and international law. And that happens in the nuclear weapons case, which is a case that happened because President Oscar Arias authorized the manufacture of nuclear fuel and nuclear reactors for all purposes, including military, plus the small detail that it happens to be that we have thorium and uranium in Costa Rica, so that decree also authorized the extraction of those minerals. Now, when I tried to demonstrate the customary rule of domestic and international law in this case, now I had one precedent in terms of case law, which was the Iraqi war case. So finally, I got the Supreme Court to recognize that. This last just as a side note. Some of the things that the Costa Rican Supreme Court took into account is that indeed Costa Rica decided to take a leap of faith when in a very short space of time, which is between 1945, when we had the San Francisco Conference giving birth to the UN and to its charter. And then it was just 3 years after that Costa Rica decided to abolish the army. And we decided that it was going to be through law and through the trust in mechanisms of international law that we will defend ourselves and make our ways in the international concert of nations. And for the Supreme Court, that was very important. There is a passage in the ruling that gets me a little bit emotional. I mean, it's still so many years after it gets me a little bit emotional, because it does recognize that we as a country have decided that whatever price it would be paid for recurring to peace would be by far lesser than the price that would be paid by recourse into war. And that understanding, besides the trust on international law, made this opinio juris, this will of the state, the fundamental element for the Costa Rican Supreme Court to recognize the existence of this customary rule of domestic and international law. So in some way, the court found that this support was a breach of that fundamental and transcendental leap of faith that Costa Rica decided to take in 1948 when we decided to found the Second Republic. The Supreme Court understood then that as there is a constitutional obligation to abide to international law, and the invasion of Iraq was not in accordance to international law, as it was not in accordance to the UN Charter, there was a violation of international law because Costa Rica couldn't support an action taken in contradiction or in breach of the charter, which in this case was the unauthorized use of force, that there was also a violation of the Vienna Convention and the law of the treaties because Costa Rica had sacredly promised and solemnly promised to abide to the strict obligation, not just to the refrain of use of force as established in peremptory norm, customary rule, and Article 2.4 of the UN Charter, but also because of its obligations to peace. And also because Costa Rica depends on this for its existence and survival. It is everything for us, international law. It is with international law that we managed to repel the Nicaragua invasion in 2009 without one single battle, without one casualty, without one shot fired. We went to the ICJ and we trusted the mechanism, and it worked. And it worked. And finally, the Supreme Court understood that there was a violation of the neutrality statement, and there it found that the neutrality statement constitute a unilateral declaration of international law, and by supporting one of the parties in the conflict, the government was in transgression of the rule of venire contra factum proprium, which means that you cannot go against your own acts. So by declaring Costa Rica neutral, then Costa Rica cannot act against that declaration. And that's it. I think, as Forrest Gump said, that's all I have to say about that. Yeah, I think that's all I have to say about that. Those cases, they were not just an important tool, but they showed that, I mean, they show a few things. One is that, to be honest, the United Nations or the ICJ or any international tribunal are things that shouldn't exist if states would, in good faith, just behave properly and according to the law. And it is the lack of this will of the state that makes the necessity of these institutions that, as Richard Falk mentioned, for as faulty as they might be, we are better with them than without them. And it's not because institutions don't work, it's because because states don't want these institutions to work. The other thing that I think that is valuable is that it shows how legal tools can be used by regular earlings for peaceful purposes, on even to make an arrêt, to make a stop on the states, on the performance of certain actions. It is true, and I do have to acknowledge that in this particular case, the Supreme Court decided to overthrow the theory of acts of state or acts of political acts, which was a very strange legal theory that breached the principle of constitutional supremacy, because it allowed the state to make certain political decisions that would be beyond the legality check of any court or any jurisdiction. So this case was a limit case in terms that the court had to confront itself with a situation where the traditional 200-something old theory of political acts couldn't stand anymore. It faced in a scenario where the use of these discretional power that should have never existed under the principle of constitutional supremacy was so gross to the bone of the spirit and nature of the Costa Rican people that it couldn't be allowed. And as a personal thing, what I want or I make valuable of my experiences in these cases is, as Marjorie mentioned, both, well, except the prohibition of weapons against demonstrations, which I was a lawyer by then. The first two cases regarding the Iraqi war and the provision of nuclear weapons and the recognition of the right to peace that derived from that second case were cases that I took before the Supreme Court when I was a law student. The other case and the gay marriage ban case, I was already a lawyer. And when I filed these two cases, I really had no hope of winning either of those cases. But I did. And it changed everything. For my country, for me, it opened a window of light for other countries. It created the first step. It put the stepping stone. And you would think, well, yeah, but it's Costa Rica, man, like nobody cares about that because it's a very small country. But then I will have to disagree with whoever has that view. Costa Rica is the most important country in the world for one reason, is the threshold. And it's the country we got to be most careful about because it's a threshold that we cannot allow to lower. And I was a kid, and I was not a good student, and I'm not the smartest person in the world. Marjorie can tell how dumb I can be sometimes. It's very dumb. But I had a cause that I thought it was right, and it was worthy, made the effort. And that decision of making the effort, which sometimes we'd rather not do, changed everything. So give it a try whenever you have a chance. And I think that's all I have to say, Marjorie, for real, and I can finish.
Thank you so much, Roberto. You are an inspiration. Dumb is never a word I would use in the same sentence with your name. And you had an uphill battle in these cases, but I remember the saying from the 60s, dare to struggle, dare to win. And I think that that is a theme that we should keep squarely in mind, not just in the courtroom, but in the streets as well. And people are showing that all over the world in opposition to the genocide in Gaza. Thank you, Roberto, for talking about how uniquely, I believe, at least in contrast to the United States, when Costa Rica undertakes a commitment under international law, it automatically becomes binding domestic law. It's self-executing. The U.S. is famous in attaching reservations to the ratification of treaties, saying this is not self-executing. In other words, Congress is going to have to pass implementing legislation. And also the right to peace that you brought to the fore in the nuclear weapons case, and how you convinced the Costa Rican Supreme Court that the war in Iraq was illegal and Costa Rica should withdraw all support. So very inspiring presentation. Now we would like to open up the program for a discussion, and we would like to begin with a discussion between the faculty members about issues that were raised in your various presentations that you might want to elaborate on or respond to amongst yourselves. And then after that portion, we will open it up for questions. That I've been noting some of the questions from the Q&A and the chat from the people who have registered. So Richard, Sujith, Dave-Inder, and Roberto, please respond to each other in any way that you would like.
Well, I'll just start with a summary, which is that it sounded to me that there was broad consensus that the system, put in place by the charter is deeply flawed, and I think that there was more debate that I heard as to where to go in terms of does the good outweigh the bad? Can it be reformed? Does it need a whole-scale revision? Is revision possible? I mean, I think those are kind of interesting kind of conclusions that I think that each person probably has a very different opinion on, and I mean, that might be an interesting place to start.
Richard, I think you're muted.
I make most sense when I'm muted. I think that Dave raised a good starting point for a discussion when he said that we were in a consensus about the UN being flawed in its conception and performance. I'm not sure how one intends the word flawed to be interpreted, because from the perspective of those that were instrumental in establishing the UN, it's more or less served their goals. In other words, they wanted it to be weak. They, at least I think, the moving forces in the creation of the UN, and they wanted geopolitical primacy to persist. They didn't want a world governed by law. And therefore, from the very beginning, it was a struggle against the management of security through power rather than through respect for law. And I think that's a fundamental issue when we're talking internationally. The Costa Rican presentation was very stimulating in the sense that, and yours too, David, was very stimulating in the sense that it showed that there's a great potential for using law to awaken civil society within national legal systems. And universal jurisdiction is perhaps the peak of that effort to supplement what doesn't work internationally by creating legal options within sovereign states. And just finally, in relation to the very interesting presentation by Sujith, which I think that maybe people like myself emphasize power too much and the racialization of power too little. And I think it's a real TWAIL contribution. I've been involved in various ways over the years with TWAIL, that it has introduced this perspective. But there's a danger in totalizing the perspective, because it's not only people of color that have suffered, and one needs to keep in mind vulnerable minorities in countries that are part of the hegemonic dimensions of international society. So that my view is that this discussion of reform or abolition, I mean, it's a sort of scary word in this context. And one thinks, at least as an American, of the abolition of slavery, or maybe the abolition of colonialism. It doesn't create continuity, and maybe that's the purpose, to establish a zone of discontinuity. But it overlooks, in the UN context, the positive elements of the UN performance outside the peace and security area, so that maybe one needs to stress even more than I did this distinction between how the UN functions with respect to the management of power in the world, including the use of force, and how it addresses a series of other issues in which its performance is much less subject to geopolitical manipulation. Let me stop there. Probably said too much. I was better muted.
Roberto, did you want to jump in, or?
Well, I do think that indeed the UN is the result of the juggling more than balancing of powers of those who actually had some power. Costa Rica, as a founding member, didn't really have any, but those who made it to the seat, the permanent seat of the Security Council, were the ones really deciding how the juggling was going to take place. And the sole existence of permanent members, it's a violation of one of the most basic principles of international law, which is the equality among states. All the states are equal, but not really. We have 5 very privileged ones that are superior to everybody, at the point that they can use the non-concurrence of their vote. The veto does not exist in the text of the charter, but they have used that non-concurrence against the purposes of principles of the charter, which is something we can infer from the Israeli-Palestine situation if we go beyond the many specific resolutions and we just take into account that for 70 years the issue remains unsolved. So it doesn't matter how many resolutions or what these resolutions have said, the issue remains unsolved. And what the charter requires is that the Security Council takes effective measures. And measures have not been effective to stop the genocide. So there is a fundamental problem there. There is the result of the juggling of powers of the P5. But as paradoxical as it can be, the becoming of the word from a bipolar word to a unipolar word didn't help at all. And in that regard, the uprising and the growth of the Russia and China for the much dislike of the West is a good thing for the world, because it is breaking again the unipolar system and is bringing light to a bipolar system, and hopefully we become a multipolar system as the global south is getting together and rising, as we see the alliances in Africa and in South America, and the non-aligned movement is still strong, and we have the BRICS. And so I think that by the weight of development of international affairs, change will have to happen against the much likes of the P5. But at some point, it will become unsustainable for them to hold the system. I do hope that it happens soon, and well, for whatever means, but if the Palestine situation and the Palestine genocide haven't been the last straw, it should become the last straw soon.
So if I can jump in here, I guess I'd like to make 2 points. The first is, actually, let me flip it around and maybe deal with the history of race first, and then try to get to, Dave-Inder, your point around abolition, or how you framed it. And for me, while I think it's important to think that there are other social markers that may be relevant in how we think about oppression, I also think that it would be really dangerous to ignore the fact that race was the central animating ways in which people were colonized. And race was central to how the capitalist structures have been forged. Right? So, Professor Falk, coming back to your point around the totalitizing of race, I think I would have to part ways with you respectfully on this, because I think race has played a significant role in how our capitalist structures have been constructed. Without the enslavement of peoples by Henry the Navigator in the early 1400s, 1500s, etc., the construction of the capitalist order that we find ourselves in, what would not have been possible? So to kind of remove race from that equation, I think does us a disservice, especially as we think about the global legal order now and the role of the United Nations and global governance in particular. Right? And so while I think that gender, sexuality, etc., and other social markers are essential, I think race and gender and sexuality and class have all now come together to kind of forge this identity in which race is ultimately about power. And so if we don't think of it carefully and in a nuanced way, we also, and if we try to sideline it as, it's too totalizing, then we ignore the historical aspects of how the structures came to be. And I think the work that's being done in critical race theory and TWAIL and the merger between those two spaces has been really productive. And especially the work of Nora Arkat and John Reynolds and Daryl Lee in thinking about race in the context of Palestine, I find really productive when we're talking about race. And I guess the other piece on abolition, Dave-Inder, I think your summary was really useful for me because, I don't know, I guess coming from the space that I'm coming from, we're often told that international law will give us freedom. Right? Every time I go back home to Yalpanam or to the northern part of Sri Lanka, the mothers of the disappeared would often say, why can't the UN do something for us? Why can't the UN help us find the sons that we've lost? And I think, there's a false narrative here, right? In that we often ignore the fact that international law, and as Tony Angie has clearly laid out, international law was essential in forging the ideas of sovereignty. And without international law, we won't be able to kind of think about the ways in which all of this unfolds, right? And so the false narrative that I think we're being fed is that emancipation is possible through law. And I'm not so sure. I don't think that's the answer for me, anyways. And as we're witnessing, you know, I was earlier before this discussion, I was on Al Jazeera, and I think the Israelis are talking about flooding the tunnels in Hamas or in Gaza with salt water. And you know, as we witness all of this carnage unfold, I'm not so sure that international law will ever get us what we want. And in fact, I think it's kind of an illusory, or it's not a real thing. Anyways, let me stop there.
So if I could just jump in quickly, because I wanted to just add my 2 cents to my own comment, I guess, my own summary, which was that I think we're kind of in a moment of, and this is kind of the legal, I really enjoy reading a lot of legal theory, and from a legal theoretical perspective, you know, I think we're really in a crisis of sovereignty, right? Like the sovereigns that the Council of Sovereigns that emerged after World War II has failed to provide genuine global security that I would say is consistent with what we think of as universal human rights. And we're seeing that, right? And the sovereigns themselves concede that in a lot of ways, that they're weaker than ever I mean, they're more powerful than ever technologically, but they're weaker than ever from a moral, ethical, legal perspective, from an advocacy perspective, from resolving the 75-year dispute, right? And so it reminds me of the state of nature. Like, I think you can read Hobbes, and it's like, well, we're living it, you know? So I think that we're in a moment ripe of possibility. If I can just be positive, put some positive spin on this in the midst of all this destruction that we witness daily on our phones, that I'd like to think that there's some possibility here of a kind of a human rights sovereignty. And that's my passion, and that's some of my research, is thinking about how we can recharacterize governance in a way that we focus on human rights and legitimizing human rights as a global concept. We focus on planetary stability, right? And then maybe focusing on discrete issues within those realms can lead to different or augmented institutions. I don't know what those are. I think we also face a challenge of imagination. I really think we like one of the big issues that I think about all the time is like, what does the world look like when these problems are resolved? And how do we get there? And you kind of want to watch a movie. Like, I'd love to watch a movie about how that happens, or like read a book. But I think that reflects the stunted imagination that's in our collective consciousness. And so part of what I'd like to hope to do is hopefully inspire people who are listening to this, that in the midst of all the things that go on in the world that are terrible, that maybe there's some room for possibility, and to build a world that I think we all instinctively know can exist, and I think about daily, why doesn't exist, you know? But that's how I kind of conceive of next steps. And I don't know how the Charter or the UN would fit into that. I mean, it's possible that we come up with a completely different institution that sits alongside United Nations mechanisms. I mean, people have talked about a global parliament, for example. I don't know if that's a solution, but it's an interesting idea that would be it could sit outside the Charter, it could sit inside the Charter. We could come up and devise other kinds of judicial mechanisms. We could devise other authorities that might sit regionally, like in the Arctic or in the Pacific, to protect fragile ecosystems. I mean, I think that's the kind of thinking that I think is useful, is thinking about, okay, well, what is the world that we want to build, and what does it look like? But yeah, I'll stop there.
At this point, I would like to highlight some of the questions from the registrants, and I think I'm going to just kind of crystallize them in 4 different questions, and then perhaps anyone among the faculty can respond to some or all of them. First of all, has post-World War II military aggression in violation of the UN Charter changed customary international law so that powerful states are free to violate international law with impunity, and international law will hold only the less powerful states accountable? In other words, is the international law of conflict a tool to allow the unlawful use of force? Secondly, does the prohibition against aggression carry any weight today. And this, of course, raises issues of the Rome Statute and the definition of aggression and whether it is in a different category under the Rome Statute than the other three crimes: genocide, war crimes, and crimes against humanity. Third, there has been talk about the Security Council, the veto power. What about, that's the elite body in the charter, the Security Council. What about the democratic body in the charter, the General Assembly, where every state has one vote? What about the Uniting for Peace resolution, which says that when the Security Council cannot or will not, because of a deadlock among the permanent members, fulfill its obligation under the charter to restore or maintain international peace and security, then the General Assembly can take up the issue. It is not binding, but carries great moral weight. Why isn't Uniting for Peace used more frequently? And then the other question I want to flag is, should there be another international body aside from the UN created, established in the global south?
Okay, maybe I can jump in. So there is a few things that I think is important to take into account. One is the fact that if a rule is violated, it doesn't mean that the rule is wrong necessarily. So in that regard, the breaches to the obligation to refrain from the use of force cannot be considered legal and then cannot be useful to overthrow the rule's existence on that prohibition. It was not until the 1984 ruling from the ICJ in the Nicaragua case that they very openly stated the customary and peremptory obligation derived from the prohibition on the use of force. And yes, we can contest whether or not there was sufficient enough practice, but that is beyond the scope of what we want to deal here. The fact is that the court recognized that and issued the ruling in that sense. Then the other thing that I think is important to take into account is that I don't really think that the UN Charter is insufficient or that is flawed by nature. I think it has become ineffective, insufficient, and flawed by use, but not by nature. If states would participate in the United Nations and would follow through the legal obligations in good faith, I can assure you the world would be much different by now. The problem is that states don't want to. And I mean, the US in the case of Palestine is the most obvious scenario. There is absolutely no doubt that Israel has infinitely violated international law. There is no doubt that the occupation is illegal and has to end. There is little doubt that there is a genocide happening in Palestine, right? So it doesn't work because some states don't want to. And here is the thing with sovereignty. So making a second institution, I mean, its effect will depend again on the will of states. Like all institutions and everything on international law depends on the will of the states. And of course, realpolitik makes a big intervention here. Most powerfuls will, you know, they have the bigger stick, they will make use, they use the stick for their purposes. I mean, that's why they have the stick. Otherwise, they wouldn't have it. So I don't see neither in abolition or in fragmentation or parallelism and an exit to the thing. I mean, it's if states would comply in good faith with the UN Charter, it would work fantastically. The thing is, the states don't want, and as we don't have in international law that way to force will, I mean, there is in the nature of international law, there is this Achilles heel, and we have to be aware of that, and we have to understand that, so we don't over expect from the institutions and the agreements that have been created. I mean, we have to understand that reality. All law is the result of a political decision. The UN Charter and the action of every state is the result of a political decision. And we have to take that into account. And this goes the same for the United for Peace resolutions. Why haven't it used more? Because the states haven't wanted to. There is nothing, absolutely nothing, preventing states to recourse to the United for Peace resolution and override the legal use of the veto by the permanent five. Because United for Peace is an override of the Security Council powers. And yes, we can argue if it's according or not to the charter, but the resolution is still standing as it exists, and it's materially and in fact an overriding of the powers when the Security Council doesn't want to act in compliance with the purposes and objectives of the charter. So sovereignty is key. As they have mentioned, I don't know if the crisis of sovereignty that Dave sees, I perceive it in the same way. I think not. Yeah, I mean, at the heart of every discussion regarding to international law is the will of the states, and I just want to point that that's something we shall not lose sight of.
Maybe I can respond a little bit to what you just said very well. I don't think the focus on the will of the states as the exclusive explanation for the failure of the UN Charter to be implemented. It's also a failure of civil society to mobilize sufficiently to induce states to comply. And I think this has been a very rich discussion, but it hasn't emphasized enough the activation of civil society as an instrument of activating the charter in the peace and security domain. And I think it was famously said once, few are guilty, but all are responsible. And I really think that this expectation that the will of governments and the will of what I'm calling geopolitical actors is going to shift because it will make a better world. I see no firm indication that that's the case. I think it will only shift if there's sufficient pressure on behalf of that. And that's why I think TWAIL is important as a perspective that realizes that law without political context is bound to fail. You need an appropriate political context. And to discuss the charter without taking account of the fact that the 5 most powerful countries in 1945 took steps to exempt themselves as their strategic interests required or seem to be, their strategic ambitions led them to do, ignores the fact that the charter itself is internally contradictory. What is the spirit of the charter? Is it the articles of Article 2.4 and 51, or is it the veto power? And I'd say it's both. And that it's not just a crisis of sovereignty. I think it's also a crisis of geopolitics, that you have these actors that don't, on principle, don't want to allow their behavior to be regulated by any kind of international framework. And the US goes so far as, in respect to the International Criminal Court, of declaring an congressional intention to interfere with the court if it dares to indict any American citizen. I mean, one has to take into account this meta-sovereignty level of international behavior that accounts for much of the tragedy and the suffering that we now take note of in the world. And of course, strikingly relevant is the contrast between Russia's attack on the Ukraine generated some kind of response in the global West, where the Israeli attacks on the people of Gaza has been completely inverted. In other words, Israel has been supported basically by the global West. And I would share the view that part of this double standards is certainly its racialized dimension. But it's not the whole story. And that's really what I think we have to come to grips with, the complexities of international society, because otherwise there'll be a tendency to factionalize our diagnostic views of what's wrong and what to do about it. So one at this stage needs to be open to building, as I think you said, Sujith, a big tent to allow this kind of debate that we're having to take place. He stopped.
Dave-Inder, did you want to?
No, go ahead. Go ahead, Sujith.
Thanks. So I guess let me kind of try to respond to two of the questions. The first on aggression, and then the second on an international institution for the global South. And I guess on aggression, I think for me, and let me kind of speak in the general terms, because I know a lot about genocide and war crimes. I don't know that much about aggression in terms of its history, et cetera, except for some of the earlier debates that Justice Powell was part of. And so for me, in the context of the ICC, I think aggression will become proceduralized in the same way as we have seen how genocide and war crimes and crimes against humanity have been proceduralized. And in engaging in those debates around, is this genocide, is this not genocide, one of the kind of procedural questions, or in thinking through the statutory provisions, has always been, while there are only 4 enumerated categories that can actually be victims according to the law. And I think that's a deeply procedural kind of way of thinking about genocide. And I think aggression will also suffer the same fate, right? Even though we don't have that much jurisprudence on aggression, I think, if we look at the history of how crimes against humanity, war crimes, and genocide have been interpreted, even in the context of the two ad hoc tribunals, what we see is this deep tendency to proceduralize and to kind of get into the nuances of how do we tinker with the provisions. And I think that's what, if that's what's going to happen with aggression. And I don't think aggression is going to be any different. And I will be very surprised to see if Israel is ever brought up, or if any of the individuals responsible in the context of Israel are ever brought up on charges of aggression in my lifetime. Anyways, maybe that's a bet that I'm willing to make. But now turning to the question of the global South and international institutions, one of the things, and I think Professor Falk, I think I do agree with you on the necessity of the big tent here. And I think, if we think back to the feminist movement has had this large tent that they have been working with, whether it's the first wave, second wave, or third wave. And the third wave has been kind of thought, or the queer critique of feminists has been really useful. And so for TWAIL scholars, I think this is really important to kind of think about the framework as a big tent. But that said, I'm not so sure that creating an international institution for the global South will be that productive. Because I think here we have to come back to some of the work that Fanon has done. And Dave-Inder, while I love Hobbes, I think Fanon might be a more interesting person to think about it in the sense of how to move forward in the global South. And so, one of the lessons that I've taken from Fanon is that, as the colonizers left, they left people in charge who mimicked their behavior, especially in the context of class. And so, places like Sri Lanka, for example, the elites who now rule Sri Lanka are, their proximity to whiteness is very cemented into the class structure. And so I'm not so sure that setting up another institution in the global South is going to get us out of the challenges that we find ourselves in, because I think it is about Western conceptions of law that we have to struggle with. And in that sense, I think, one of the kind of interesting pieces that's happening right now is, well, how do we go back to quote unquote indigenous ways of thinking about law? And, there are tons of scholars, whether it's in the Bolivian context or in the Chilean context or in the South African context, or in the context of Ulam in what is now known as Sri Lanka, where indigenous conceptions of law are being kind of thought about carefully, right? And of course, it's drawing inspiration from folks like Sylvia McAdam and Bev Jacobs and Valerie Vabous, where they're trying to revitalize their own indigenous conceptions of sovereignty and their own indigenous conceptions of law. And I think maybe that is where the answer lies, not in Western notions of, the Leviathan's understanding of law, but rather a different way of thinking about law and about international law, right? Not international law, but inter-national law between communities that existed prior to contact. And how do we kind of use those techniques as a way to get ourselves out of the predicament that we find ourselves in now?
If I could just respond a little bit, I would say, yeah, I've read Fanon. I think obviously Fanon is a fantastic author and provides a lot of insight. I think where I'm coming from is in a lot of the legal theory work that I'm doing, there's this concept of the exception. And I think I want to talk a little bit about the question presented about whether when the great powers violate these peremptory norms, does it cheapen the peremptory norm? And I would say it's the other way around. It shows the violations of these peremptory norms. Like, I don't think we should take it as a way of saying that these norms are meaningless. I think we should conclude the other way around, which is that there are grave violations of international law taking place practically all the time, right? And that's the world we live in. And not to say that the norms don't carry weight, but just that there isn't a way to enforce these norms, and that these powers are creating an exception for themselves, right? They've codified an international legal system and they've carved themselves out of it. And that's a fundamentally unfair thing to do for people in the global South, for people who are marginalized, for victims anywhere of whether it's aggression or any other grave human rights violation. So, the way I conceive of it is, again, thinking about how to move forward, is how do we end these exceptions? How do we end the exceptionalism, whether it's US exceptionalism or Russian exceptionalism when it comes to aggression in Ukraine, or name the exceptionalism. And I think for there, we have to, again, rely on thinking about, our imaginative spirits in terms of where to go. And I think where I'll end, or what I'll say, just from where I'll end, is just, I do think there has to be some mechanism to police these violations, because I think that's what we're witnessing, is the failure of accountability. I think that power corrupts, and you do get into situations where you give anyone a degree of power and you immunize them, then they're going to abuse that power. And ultimately, I think that is a problem of government and sovereignty. So I think legal theory provides a little bit of guidance there. But yeah, I'll stop. I'll end there.
Well, I want to thank you to all of our faculty for such a provocative program, for grappling with the contradictions between the Western powers and the global South, contradictions between the Security Council and the General Assembly, contradictions between people of color and white people, colonizers and colonized. And also, I want to thank the registrants for participating and attending. We hope you will attend future courses and seminars. Our next program in the People's Academy of International Law will be a seminar on the right to a clean and healthy environment. That will be held on Thursday, January 18th, same time, 9 o'clock Pacific, 12 o'clock Eastern. If you registered for this program, you will receive an email reminding you about that program, sending you a Zoom link. So once again, thank you so much. We're delighted that we've had so much success just getting the People's Academy of International Law off the ground. And we hope that it will continue and thrive, and all of you make that possible. So thank you again so much, and we hope to see you next time.